Right. Good afternoon, everybody. Thanks for joining today's webinar. We want to discuss, because it's quite timely, we want to discuss the Illumina Grail judgment, which was rendered by the Court of Justice, the General Court, the first instance court of the ECJ, last week, Wednesday. And we want to share some initial thoughts with you on the new approach to Article 22 of the EU merger regulation. And it's really quite interesting because as compared to the enforcement practice of the last 20 years or so, even more, it's been quite a shift of enforcement, whereas the merger regulation, the EU merger regulation, was designed to provide a fairly clear-cut jurisdictional test to decide whether a particular transaction is notifiable or not. The EC and now also the General Court is emphasizing a bit more flexibility to review transactions which they think could significantly impede competition. So to that end, Article 22 of the merger regulation is now used to review transactions that do not meet the turnover thresholds either at European level or at national level. So this is the topic we want to discuss today. So with me, we have Jakob Westin, who is the lead antitrust lawyer for Takeda in Europe. And not only that, he's also on holidays. So I thank you, Jakob, very much for joining our seminar today, despite being on holiday. And we have Strati Sakellariou, who is a partner with me in the Brussels office of White & Case. So before Strati will discuss the Illumina Grail transaction in a little bit more detail, and before we discuss with Jakob and Strati sort of the practical implications, at least some initial thoughts on the practical implications of the judgment and the new approach to Article 22, I just wanted to give you a short overview of the developments in merger control enforcement leading up to this judgment. So, Article 22, it's not a new provision. It's been in the merger regulation ever since it came into force in 1990. However, at the time when this was put into the merger control regulation, it was meant to allow member states which did not have their own merger control rules in place yet to refer a transaction to the European Commission for review. There were, in fact, quite a number of those jurisdictions which did not have their own rules, one of which were the Netherlands, which is why this clause, Article 22, is kind of known as the Dutch clause. However, over the years, almost all member states have implemented merger control regimes. The only one which today still hasn't one is Luxembourg. And therefore, the European Commission has, over the last 10, 15 years, discouraged national antitrust authorities to rely on Article 22 to refer cases to the European Commission in case their own jurisdictional test hasn't been met. And as a result, in fact, there were very few Article 22 referrals over the years. There were a few, and in fact, also the court judgment named a few. As far as I can see, most of them were cases where at least one member state had jurisdiction, referred the case under 22 to the European Commission, and then some other member states joined in. So that's sort of the historic background to Article 22. Over the years, however, there was a perception, both by the European Commission and the national antitrust authorities, that there was an enforcement gap. There were too many cases which were picked up because of the turnover thresholds, however, which did not cause any concerns, hence various attempts to simplify the procedure. While at the other side of the spectrum, some acquisitions which were potentially raising antitrust concerns weren't reviewable because it was not notifiable anywhere in Europe. There was also some discussion about minority shareholdings. Should we review, or should the European Commission review acquisition of minority shareholdings? That was reviewed but shelved again. That idea was dropped. But really the idea of big transactions with a high purchase value, big companies buying startups, nascent companies, the so-called killer acquisitions, they often were not reviewable simply because the target either a digital company with some startup that hadn't brought any product to the market yet, or a pharmaceutical product, a molecule still in phase 3 development, no turnover yet, so therefore not notifiable yet. Those acquisitions, those transactions, not notifiable because again, none of the national or the European tests were met. So how to address that? For a few years, and this goes sort of back maybe to 2016 or so, for a few years there was a discussion whether the European Commission should introduce value-based thresholds in the merger regulation. There was a debate, which would be the right level, what is the right purchase price value, is it 1 billion, is it 5 billion, a bit like in the US. In fact, Austria and Germany at the end of that debate have introduced and still are applying today value-based thresholds. As far as I can see in Germany and Austria, it's actually fairly rarely used, but it is used. By contrast, the EC, the European Commission, did not go for this approach because they couldn't really find the right threshold. So someone then must have gone through the merger control regulation and discovered Article 22 again. So in a speech in September of 2020, Commissioner Vestager announced that Article 22 will be brought back to life. In fact, by encouraging, not discouraging, encouraging member states to refer cases to the European Commission, even if their own national jurisdictional threshold was not met. And then finally, in end of March of last year, 2021, the EU issued a guidance paper, which specifically encourages member states to rely on Article 22.2, and I quote from, in fact, Article 22.1, to refer any concentration which affects trade between member states and threatens to significantly affect competition in that member state. So that's the test: trade between member state and threaten to significantly affect competition in that member state. So instead of discouraging member states, the EC is now actively encouraging member states to refer cases under Article 22. And in fact, the first case, the first transaction caught under the new approach was Illumina's acquisition of Grail. And over to Strati for more details on that transaction and the judgment from the GC. And I may add, before handing over to Strati, you will be able to ask questions to the three of us by sending an email. And there is an email address somewhere, I think, in the chat. Please use that. And we will see your questions in our email system, and we will respond to them time permitting. So with that, over to Strati for the Illumina transaction and the judgment from the GC.
Thank you, Axel. So I will briefly touch upon the background of the transaction and then discuss two main findings of the judgment to frame the discussion that will follow. So here's what this case is about. In September 2020, when Axel mentioned that Mrs. Vestager had the famous speech about the revival of Article 22, and that's almost 2 years ago now, Illumina announced its intention to acquire Grail for the amount of $7 billion. Illumina is a supplier of next generation sequencing instruments, consumables, and services. This is called NGS systems in abbreviation. These systems are used for genetic and genomic analysis. Grail, on the other hand, is a customer of Illumina. In fact, it was founded by Illumina 6 years ago, and Illumina used to hold a minority stake in Grail. Grail develops blood tests for the early detection of cancer, and for the development of and commercialization of those blood tests, it uses the NGS systems that I mentioned, and like the one supplied by Illumina. The proposed acquisition of Grail by Illumina was notified in the US shortly after the announcement. It was not notified in the EU, however. Why? Because Grail had no sales in the EU at all, and therefore the turnover thresholds of the EU, and the national merger control regulations were not triggered. 3 months post announcement of the transaction, in December 2020, a complaint was filed before the European Commission against the transaction. And 2 months after that complaint, the Commission decided to invite the national competition authorities to refer the transaction to it for review under the Article 22 of the merger regulation. Shortly after that invitation by the EC, the French National Competition Authority requested the Commission to examine the transaction under this referral mechanism. And a few days later, another 5 member states joined that referral request. Greece, Iceland, Belgium, Norway, and the Netherlands. This shows you also which national authorities are pro this referral mechanism. The Illumina tried to challenge those referral requests before the French and the Dutch courts and tried to stop the authorities from requesting referral, but both challenges were actually unsuccessful and rejected by the national courts on different grounds. And now this is all happening just before the Commission issued its new guidance that Axel mentioned on Article 22 and the revival of the clause and the new scope in the end of March 2021. Just after the guidance was issued, the Commission accepted the referral request by the French Competition Authority. And after that, the parties notified the transaction, in fact, to the Commission. The Commission opened an in-depth investigation on the basis of vertical input for closure theories of harm, arguing that post-transaction Illumina might have the ability and incentive to limit innovation efforts that could lead to alternatives of Grail's technology. And while this review by the Commission was ongoing, the parties closed the transaction, and the Commission then opened a gun jumping investigation against the parties, and it also imposed interim measures that require now Grail to be kept separately from Illumina and be run by an independent, whole separate manager. So a lot of different procedural issues that arose. But let's go back to the judgment, because Illumina challenged the Commission decision accepting the referral before the General Court. And the General Court decided on this action just last Wednesday, on July 13th, and this is the judgment that we're discussing today. So in my view, there are 2 main takeaways from the judgment. The first one is whether the Article 22 referral mechanism can be invoked when there is a national merger control regime and the merger control thresholds are not met. In other words, was the request for a referral by the French Competition Authority and the acceptance of such request legitimate? And the second question is that if it is legitimate, which the court answered yes, until when can the referral request be made by the national authorities? Now, regarding the first question, the court confirmed that the national competition authorities can request referrals, even if their national merger control rules are not triggered. The court clarified, it went through a historical and teleological interpretation of Article 22 and textual interpretations. It's an interesting judgment in this respect, and clarified that although the Article 22 referral mechanism was initially established to allow referrals from member states that did not have merger control rules, Axel mentioned the Netherlands. By now, by the way, there is no EU member state with no merger control rules, maybe just Luxembourg. The court clarified that the mechanism is not limited to those situations. Rather, the court concluded that the Article 22 mechanism is, and I quote, an instrument intended to remedy control deficiencies in a system based principally on turnover thresholds. Effectively, the court here agrees with the Commission that Article 22 is the mechanism to examine what was mentioned in the introduction as an enforcement gap, where we have cases that could impact competition but there is no possibility to review them because the turnover thresholds are not met. There is another interesting quote in the judgment, which says that it can be invoked only, again, and I quote, in certain specific cases under very specific conditions. And what does the court mean in this respect? It means the 4 cumulative conditions that are required for Article 22 to apply. Which are those? First, the referral request must be made by 1 or more member states. Here is France, box ticked. Second, the transaction must satisfy the definition of concentration. That means that the transaction must involve a change of control on a lasting basis. Third, the transaction must affect trade between member states, and we will be discussing that requirement later on today. And lastly, and importantly, the transaction must threaten to significantly affect competition within the territory of the member state asking for the referral. So bottom line, referrals like the one in Illumina Grail are here to stay. That's the first takeaway. The second question examined by the court is, and I should say that Illumina has appealed the judgment, so maybe this takeaway will change, but until then, let's see. The second question examined by the court which will also have wider implications for future deals, is timing. Until when can the referral request be made by the National Competition Authority? Until when will we have uncertainty as to whether the deal would be reviewed under this mechanism? Under the merger regulation, a referral request can be made within 15 working days, either from the date on which the transaction is notified, or if there is no notification, such in the Illumina Grail transaction, within 15 working days from when the transaction is made known to the member state. In this case, Illumina argued that the referral request was submitted out of this 15-day deadline. So what did the court said about made known? What does it mean? When does a 15 working day deadline start? The court said that making known should be understood as the active transmission of information to the member state concerned. The member states should have all the information necessary to assess the 4 conditions that we mentioned, and especially the last 2. Now, in the Illumina Grail case, the court considered that the transaction was made known to the French authority after the Commission sent its invitation for referral in February 2021, and therefore found that the referral in March was made in due time. Interestingly, the court clarified that the Commission should act within a reasonable time limit, and it did find that the period of the 47 working days between the complaint and until the Commission decided to send the invitation letter was actually too long. So there is a criticism to the Commission there. However, the court concluded that the parties' rights were not breached because they were heard before the adoption of the referral decision, and they didn't have to be heard before the invitation letter was sent. So we are left effectively with a lot of flexibility in terms of timing for the Commission and the member states, unfortunately. And on the other hand, quite a lot of uncertainty for the parties. And with that, Axel, over to you to kick off the discussion.
Yeah, thanks, Strati. Right, yeah, no, I mean, the 4 criteria that you mentioned, it's a somewhat soft test, I would argue, but there you go. So, Jakob, I mean, you are being consulted by your business development people, probably not on a daily basis, maybe, but quite regularly. Hey, we want to do this deal. Don't you agree that this is not notifiable? So what's your view on all of this? How does this make your life more difficult?
Well, it certainly make, maybe not my life, but the life of a big pharmaceutical company that do a lot of transactional acquisitions of this sort. certainty, everybody wants certainty. And that's the beauty, of course, of the thresholds that we have had so far. And I think that was also very much the ethos behind the merger control regulation back in the late 80s when it was developed and when it came to force back in 90 or 91 or whatever it was. The whole idea, and it was quite controversial at the time, whether the European Union at all, or European communities at that time at all, should have a merger control regime, because there were a lot of arguments that they could handle mergers and acquisitions of this sort by way of, as an abusive behavior, if that was the situation indeed. And quite frankly, I think that was quite a good approach, especially for these kind of the sort of the problems that they think they're addressing here, the whole notion of killer acquisitions, where the Commission has a sort of theory that big evil companies will want to buy and kill small startups that may come to threaten their products or business down the line. I think that's a very odd thing to think, and I know that the Commission has they have launched an investigation into this, and they've hired some Italian company to look into whether they're actually whether killer acquisitions is a real problem or a real issue, and I think they will find that it isn't. But we'll see what the outcome of that will be in due course. Coming back to Article 22 and your question, Axel, what I can tell my business development colleagues when they come to me is, and they are looking for certainty, and they say, well, this is below the threshold, so we can just go ahead. Can we not? And the answer then will, of course, be not really. You have to think very carefully about how we structure it and how we present it. And if we want to proactively go to the competition regulator or the European Commission or the national regulator to inform them or have some sort of pre-notification meeting, whether we need to notify or not, would be one option. And I think here we have the Commission might have shot themselves in the foot here, because if everyone starts coming to them all the time because they don't want this uncertainty or this, when you make an acquisition and you start to implement it, and before you know it, you have people who want you to notify it, and you have gun jumping issues and all sorts of issues that you don't really want. So maybe the option would be then to go to the Commission in advance and ask them about this, and then they have a complete new workload that maybe they want it because they will get bigger insight into these sort of transactions. But given the way that the whole merger notification process above the thresholds, the sort of the normal notification, how that's evolved over time with long gone are the you make your notification by the post, and then 30 days or 25 working days later you have a clearance in the vast majority of cases. Is long gone, and we've now have a merger notification process that takes a lot longer, even for relatively straightforward mergers. Yeah. And now you add a new chunk of acquisitions of companies that are below the threshold, have no, as Grail, have no turnover at all in any European jurisdictions. Although obviously the 7 billion acquisition price was, indicated that this is an important transaction, even if the target didn't have any turnover. So I don't know, Axel, I probably said far too much and gave you more than you asked for.
I think, yeah, I know I asked for it. I think it's fairly, well, I guess it's uncontroversial, that, sort of put it simply, that important transactions may merit a review, right? So if that's the way forward, and I have to say, when I read the judgment, the word flexibility comes twice or three times in that particular section, and finally we've got Article 22, which gives us this flexibility to sort of to close the enforcement gap. Okay, as you said, I'm not sure that flexibility was something that the merger regulation was supposed to provide, but okay, there is a certain logic to that, admittedly. But if we have that and you talk about the workload, maybe we can also discuss with the European Commission whether at the other spectrum, we should maybe have another round of a simplification process. I mean, we're still notifying joint ventures that take place somewhere far away from Europe just because the two parent companies generate turnover in Europe, right? Is that still the right thing to do? But okay, I mean, that's maybe for another discussion.
Yeah, but it's an interesting question, and I think that's pretty much the way the Commission went with collaboration or agreements that where you had to notify in the past, and since 2004 you don't notify them, or you do a self-assessment, and they can address the agreements that they find interesting or that people complain about and so on, and maybe they could change the merger control to some, along those lines. I don't know if that would be feasible or indeed practical, but I think actually, in truth, the self-assessment process for Article 101 agreements has worked pretty well, actually, and I don't think anyone complains too much about the uncertainty, and instead you do your own assessment and you go ahead and so on. Yeah. So maybe that is an option. I don't know.
Yeah.
But isn't also why we praise the merger regulation has been so successful, specifically because of this legal certainty. We're saying, oh, we have all these precedents, parties have certainty, know how they are to assess a transaction. They know how long more or less will take, what would be the issues. That's why, for example, we say that, having industrial policy consideration, the merger control regulation doesn't really fit because it creates additional uncertainty. So just introducing this type of mechanism, and which is not limited to a specific sector, pharma, digital, but could be very much wider, just in case there is a competitive potential in the target. How do you judge that competitive potential? Just because there is just a startup that may have potential, it may not have any potential. The standard, what is the standard? I think this is the question. What is the standard really we're looking at here from the Commission? What type of evidence?
That's a very good point, because Jakob knows this probably much better than we do, but I haven't seen yet in 20 years of private practice, I haven't seen yet a transaction where a company was buying a loser, right? You always buy another company because you see some potential there, right? Some benefit, some advantage for your own company, right? Is that automatically then meeting the threshold as Strati sets it out? It's yeah.
And the question is, we're talking about the enforcement gap. I mean, are we going back to some sort of a sniff set? Oh, big number, we said 7 billion. Oh, that must be important. That must be, or are we looking for something more concrete? The guidance says about the prima facie evidence that there is some significantly threatens the competition, the potential transaction, right, in a specific member state. But then we have all these theories, as Jakob mentioned, about killer acquisition, zombie acquisition, or just reduction of innovation at industry level. Is that enough?
Can I just ask another question to Jakob? As I said in the intro, there was 5 years ago, there was the attempt to introduce value-based thresholds, and Germany and Austria have done it. They're applying it, kind of working. Would that have been better?
I think maybe it would have, because at least it's some sort of, certainty that, because there is a threshold, either you're above it or you're below it, depending on how you count and so on, of course. But I think maybe that would have been something that would have given us a little bit more certainty than just somebody is interested in this, and so they make a complaint, and a member state goes and asks the Commission to investigate. And to Strati's point, of course, it is, you do you should do a very thorough analysis or due diligence of a acquisition target before you decide to go ahead and pay $7 billion for something that doesn't have any turnover or sales at this point in time. And so it's understandable that regulators would have thought that Illumina in this case would have seen something that made them very nervous about the innovation that Grail had up their sleeves, and wanted to pay $7 billion for it before they've even seen any evidence that it actually could be sold and so on. So I can understand where this is coming from, and also in the wider spectrum of the Commission wanting to be seen as someone who's protecting innovation and or encouraging innovation and making sure that innovation is not killed off and so on. So, but again, I'd be very interested to see the outcome of this, the study that they have commissioned about killer acquisitions, and whether this is a real issue or not.
There was one point which we also just got a question from Marcello Caramazza there from Clarion, sort of starting the clock. I mean, when does the 15 business days start? I mean, what does made known really mean? Strati, any views on that?
The court doesn't give much clarity, I'm afraid. It says active transmission of all the information necessary to the member states to be able to assess the four cumulative conditions of Article 22. And I think and then it finds that the invitation letter of the Commission was actually when the French authority understood about the implication of the transaction. That's 7 months post announcement, and 4 months after the complaint was lodged before the Commission. It's a long time, and I don't think that the judgment really gives clarity there. I mean, it seems that in practice, if we take a very cautious approach, the parties would need to notify in 27 member states, so that all the authorities are aware of the transaction. That's going to be some sort of mini merger notification, and then you can manage the risk. And then the 15-day deadline you count, then you close quickly, and then there's no gun jumping investigation or anything. Of course, that's not efficient. We're moving from one stop shop to 27 stop shop. It cannot be the case. So I think this is really something that the Commission would need to think about going forward, and further guidance needs to be provided there.
Yeah. How would you do this, Jakob? Send a mini notification to 27 member states, or call the Commission, say, hey, we have this deal. What do you think?
I don't think it's realistic to send a note to 27 member states and wait for them to come up with their various comments and so on. So if anything, I'd probably be approaching the Commission and ask the question whether they would allow that. I'm not so sure, because they would, as I said before, they would potentially get loads of these questions and have to make sort of early assessments, which they obviously don't want to do, and I'm not even sure that they can do it. So I'm not really sure how this would work. I would imagine in reality that you'd have to do some sort of self-assessment here, and then deal with each acquisition as it depends a little bit on the type of the acquisition, and if it's very focused to a certain geographic area, or if it's a sort of a bigger deal. I mean, this Illumina Grail is, of course, an extreme example, which is why it's become such an interesting case to look at, because it's a pretty major acquisition, and obviously coming back to the $7 billion, indicating that it's a pretty significant acquisition for Illumina, even though they didn't have any turnover in any European jurisdiction. I don't know about the US, if they had some turnover there, but clearly you can see why, in the light of protecting innovation and all that, why this is something that the Commission wants. And of course they want flexibility, which, as Strati said, was mentioned on several occasions in the judgment. And flexibility is, I suppose, some would argue it's a good thing, and some would argue that you have to find some sort of balance between flexibility and certainty or predictability, especially when it comes to acquisitions, where often timing is essential. And we've seen in the recent weeks, you have seen enormous drops of valuations of some tech companies. You have the Swedish company Klarna that's gone from 460 or whatever it was, $46 billion to $6 billion in a new round of investigation of getting funding. So obviously, if somebody was planning to acquire Klarna a few months ago and at the sort of $46 billion valuation, and now suddenly a month after the valuation is $6 billion, they would possibly want to be very happy that a notification process was initiated, so that they still haven't signed the dotted line and can potentially pull out. So speed is of essence in these deals, and that's, I think, is a concern when you introduce this whole notification process, and also even above the thresholds, because the process has become so slow and complicated, which it wasn't supposed to be according to merger control regulation.
Yeah, no, that's certainly a point that both sort of practitioners, companies, but I think also the European Commission has really to address. I mean, there has to be some practical path forward, because as you say, Jakob, making a notification in 20 to 27 member states, presumably in the national language, I mean, that in itself takes already 2 months to prepare. I'm currently doing a 3+ referral to the European Commission, and that's already painful enough. But I mean, if I had to venture a guess right now, I'd say this is probably the way forward, to have some sort of Form RS for this, that you notify only the European Commission. But of course, then you have pre-notification even for Form RS. And then it has to go to the member states, and then it's made known to the member states, right? And then this whole mechanism kicks in. But I think in practice, this will have to be the way forward. Otherwise, I just can't see it.
Yeah, I guess there are two options, as you say, Axel. I mean, the aggressive approach, very quickly post-announcement closing. What does that mean? The Commission under Article 22 cannot open a jumping investigation in this case, because according to Article 22(4, the standstill obligation does not apply if the consultation is implemented before the Commission informs the parties of their referral request. Or if there is a more prudent approach, if there are indeed issues, that there will be a consultation with the Commission. In fact, a Commission official recently, a year ago, in September last year, in a merger control conference, encouraged parties to come forward and discuss with the Commission when asked, how are we going to deal with this? And so I think the Commission may potentially encourage that, but that's all I've heard, it only orally, nothing in terms of guidance there.
It's a little bit like in jurisdictions with a market share threshold, Spain or Portugal, right? Everybody hates filing on the basis of a market share threshold, because you immediately say, hey, I have a problematic deal here, but never mind, please clear. So that it may be actually the quickly notifying to the 27 member states and then quickly closing. That may actually be in some cases actually the way forward. But yes, it's interesting. Now we have 4 minutes left. I don't see any further questions. I have still a few questions. Strati, you mentioned these 4 conditions. I think a concentration preferred by a member state. Well, that's a given. That's not even a condition. So trade between member states and a significant impact on competition. I mean, trade between member states, yes, I'm fully aware that this is a very, very soft test. In this case, Grail had no turnover in Europe. Still, trade between member states apparently was affected. So I think that test also applies anytime, right? And so we're essentially left with one, right? Any thoughts on that? Sort of significant effect on competition? So that's in order. So the jurisdictional test is now baked into the substantive test, or vice versa.
Exactly. And the question is, I think what we just discussed, which on the we will be looking at creative theories of harm now, you know, especially when there is no overlap. That we're looking at potentially probably innovation of the two. Is there a reduction of innovation? And how would that look in the future? And so it goes back to what we discussed about killer acquisitions and potentially a reduction of innovation at the industry level, which we had at Dow DuPont seen for the first time, and then Bayer Monsanto. So that gives a lot of flexibility to the Commission. There is a question, I think, of standard of proof, and also there is a problem here because this type of theories of harm often remain untested in the context of merger control reviews, because the parties would have been so far, maybe this changes now with this new referral mechanism, but they have been parties have been very reluctant to appeal merger control prohibition decisions before the courts, effectively because any redress comes too late. And so will these theories be reviewed by the court? I think this is a real question, a real concern. And again, going back also maybe to what Jakob mentioned about empirical studies and on killer acquisition in the pharma industry or the tech industry. I know that there is a study in the pharma industry. I think much fewer studies, if at all, for the tech industry, for example. So I think this is really potentially a concern.
Yeah, and mentioning the tech industry, I mean, there is the DMA is on its way to be law. I think it's Article 12, which says that a gatekeeper, once designated, needs to inform the European Commission of any transactions they plan. And then, of course, this ties in perfectly with the new interpretation on Article 22. So any, even if it's a very small transaction by a gatekeeper, will now be, at least potentially, be reviewed by the European Commission.
Yeah, I think you're right. The DMA explicitly states that the national competition authorities may use the information that they have received in the context of the DMA to request the Commission to examine a transaction under the Article 22 mechanism. So.
All right.
It all ties together.
It all ties together. And of course, now sort of the Green Deal, we are looking at innovation for, you know, clean energy. I can already see that it's applied there as well. It's innovation. There's a lot of innovation coming up there. Any final thoughts, Jakob?
No, I think we'll see how this pans out a little bit. But if we're going to do 27 notifications, that's great news for people in private practice, isn't it? So, you know, every deal will have to, you need to hire lawyers in every country, and you know, it just adds a lot of, you know, red tape to something that really ought to be very fast and a speedy process. But as I said, we'll have to see how this pans out, because the Illumina Grail case is rather special.
Thank you, everybody, for joining us today. Any thoughts that you may have, send us an email. Happy to chat, happy to discuss. And well, thank you, Strati. indeed. You're also not in Brussels, so it's also an effort to do this. Thank you for joining, and well, see you next time, I hope, for another topic.
Thanks
Thank
a lot.
you.
Goodbye.
Have a great day.
Bye-bye.